Bismillahir-Rahmanir-Rahim. Subhanaka la ilma lana illa ma 'allamtana innaka antal alimul hakim. A glory to Allah. We have no knowledge except what He has taught us. Indeed, He is the all-knowing, the truly wise. Honorable Chief Justice of the Lahore High Court, my brother Judge, Justice Mansoor Ali Shah, learned judges of the Lahore High Court, the judges of the District Judiciary, learned members of the Bar and the National Arbitration Club, distinguished foreign dignitaries, leaders of the industry and commerce and the regulatory bodies. I am delighted to join you from Islamabad today to celebrate the establishment of the first office of the Chartered Institute of Arbitrators in Pakistan. In this behalf, I welcome Mr. Jonathan Wood and Ms. Catherine Dixon, who as senior office bearers of the Institute have graced the occasion to witness their first workplace in Pakistan. Thank you for joining us, sir and madam. Many experts from the arbitration world and the world of ADR have addressed this large audience at your conference today in 5 different panel discussions. They have spoken about the substance, procedure, and benefits of ADR and arbitration in specific types of disputes. I wish to advance today's discussion by expressing the support of the judiciary of Pakistan to the promotion of these 2 forms of dispute resolution in the country. At one level, courts must endeavor to spread awareness amongst the litigant public who enter the court system about the benefits of ADR and arbitration and places that they can find this service. In fact, by issuing procedural guidelines, the 5 high courts of the country can incorporate ADR in the procedural stream leading to judicial determination. The statutory body that can implement this goal is the National Judicial Policy Making Committee. For short, we call it the NJPMC, comprised of the Chief Justices of the High Courts and the Chief Justice of Pakistan for joint decision making on policy issues. In this body, if an enabling decision is taken that would be fruitful because that would provide the legal and administrative framework to all the courts and their subordinate courts for implementing and adopting ADR and arbitration in matters that are otherwise pending before such courts or which enter the judicial system. In this regard, what is necessary, apart from the said decision, is the availability of trained lawyers, or if not lawyers, trained experts who can render the service of ADR as well as arbitration, and trained judges who can deal with the advantages of these 2 forms of dispute resolution and can promote the finalization of disputes without allowing minor technical and procedural objections to prevail. The judiciary, and in that respect, I'm speaking about the administrative structure of the judiciary, can provide the infrastructure and the logistics to the institute for providing the training to lawyers and judges. Justice Mansoor Ali Shah spoke about the mediation centers that were set up during his time when he was serving as Chief Justice of the Lahore High Court. That was a very significant contribution. And I'm very glad to note that the seeds that he had sown are still growing into plants, and probably one day they would become trees. But the fact of the matter is that the bulk of the disputes are still going into litigation. And that is where we have to put a stop. This can only happen if the high courts are committed and follow up on the implementation and the provision of the alternate methods of dispute resolution by providing the centers as well as the personnel who are necessary for administering such a system and conducting such dispute resolution. I expect that the Chartered Institute would be in a position to help us in this regard and would be able to train personnel within Pakistan, bring in good trainers and give us guidance in this respect so that this practice can be expanded in the districts and particularly the subordinate courts. The second initiative by the judiciary that I can visualize is to inform the federal government about the needs for updating our Arbitration Act of 1940. Justice Mansoor Ali Shah pointed that out, but the fact of the matter is that the flaws or the weaknesses of the present system, which as rightly observed is not being availed by the litigants today, and they go for ordinary straightforward suits. Those flaws and weaknesses have to be highlighted, and that is a task which the judiciary can perform. We have now, with the changing conditions in the world, a need to integrate with the dispute resolution mechanisms that are in vogue around the world. If we do that, Pakistan can become a successful venue for dispute resolution in matters that arise between Pakistani parties and foreign parties. I think that the CPEC experience in Pakistan necessitates that we develop our arbitration centers in the country, and that would necessitate amendment in the local curial law, which would be the Arbitration Act of 1940. There is no doubt that the litigation, ordinary litigation particularly, has become choked. That stream has become choked. and we are not progressing in the disposal and decision of those matters expeditiously. One of the reasons is that apart from the substantive dispute, there are very many technical and procedural matters that arise for determination and consume a great deal of time. In our system, for instance, you would be surprised that the value of the stamp paper that is fixed on a petition or a plaint, that can become a very retarding objection in the process of dispute resolution. There are similarly, quite apart from jurisdictional factors, there are evidentiary problems that we have. Today, when digitization and technology have introduced different forms of communication that are reliable and authentic, there are cases today that come up before us even now where the failure to produce original documents during the trial has been considered by the courts below as a serious objection affecting the decision of the case. Many of these technical objections can be avoided in the dispute resolution mechanisms that are offered by the Institute. And for that purpose, I think we need to amend or substitute the Arbitration Act of 1940, which is the procedural law that governs and controls the arbitration. I'm told, and I recall from my own experience, the UNCITRAL model law provides us guidance for adoption in part wherever our own law contains defects and flaws. In this regard, we have another body, again comprised of the Chief Justices of the High Court, but also by representatives of the federal government. You should be informed that the Arbitration Act of 1940 and the arbitral law that we have is a federal subject. In contrast, we have 4 provinces and a capital territory, so we have 5 high courts. But the law is made by the federal legislature, which is our parliament. So, in this respect, the Law and Justice Commission of Pakistan is an effective body that can promote and advocate the changes and introduce drafts for that purpose. In this regard, I once again notice that the Institute may have a role to play. In presenting working papers to the Commission, explaining the concepts, the purposes, the provisions and advantages of proposed new provisions of a national arbitration law. So this is the other infrastructural logistic support that an organization, a body, a statutory body attached to the judiciary can render. And I expect that the recommendations of the Commission for a suitable legislation can become reality if it is properly propagated and supported before the government and parliament. I expect that if we do that, we can achieve progress with respect to our legislative framework. So here again, I see a very important role for the Institute. My learned brother, Justice Mansoor Ali Shah, has very emphatically spoken about his goal and his ideal for expediting the decision or disposal of pending cases, and has passionately supported the ADR and arbitration mechanisms to be solutions that address our problem and our goal. I expect that the said goal can be achieved effectively when we provide the necessary facilities, infrastructure and personnel to the people of Pakistan, so that what they find for themselves is not a poor alternative, but a workable, feasible and vibrant system that is working in the dispute resolution world of Pakistan. I see a great deal of potential for economic expansion. In fact, a great deal of economic expansion has already taken place on account of foreign investments that have come into Pakistan through the CPEC initiative and cooperation with China. These are in essence contractual arrangements, and over here again there are likely to be, and I'm sure they are in existence, many disputes, but all these disputes go to foreign arbitral centers for resolution abroad. In a sense, from an economic point of view, a great deal of cost is borne by the contesting parties, and essentially this is because we lack the arbitration centers in Pakistan which can provide effective dispute resolution to the contesting parties. It is not as though we lack talent. There is great talent in the legal community of Pakistan. You may have met young lawyers or elderly lawyers at this function. You will be meeting or may have met judges who have great interest in this field, and I think one of the younger judges in our community, Justice Jawad, has already addressed this conference. There is immense potential and there is immense talent, and at the same time it is sad that incredible costs are incurred by the disputing parties to go abroad. Even for litigation today, ladies and gentlemen, even for the poor litigant who goes to the civil court for getting a decision on his grievance, the costs are now reported to be very heavy. Litigation has become expensive, and it's not because the losing party has to pay the other side's costs. In that regard, our system is also outdated, but we consider that justice should not be costly, so the system should not charge for provision of justice. Anyway, I consider that on the material and the social levels, the economic activity in Pakistan is potentially redolent with opportunity to be diverse, vibrant and expanding. For this opportunity to be availed, structural changes have to be made in the functioning of our society and as well as our economy. For the economy to function efficiently, you are all aware that the dispute resolution available is a vital factor which will add to the progress of economic activity, productivity and expansion in the country. On the social side, the advantage I see, and I speak with experience, the advantage in ADR and arbitration is that there is comparatively far lesser procedural and technical pleas or defenses that can be taken by parties before addressing the substantive dispute for resolution. I expect that ADR and arbitration encourages or facilitates dispute resolution on the merits of the dispute. And the finest form of justice is when the merits of a dispute are resolved before the parties and they are made aware of the defaults and the wrong that one or the other commits, as a result of which the decision goes in favor of one rather than the other. The satisfaction of the parties with the resolution of the dispute on the substantive issue is something that discourages them, dissuades them from going into challenges against the decision, and in this case I'm now talking about the award. Had this not been the case, I'm sure that arbitration and ADR would not have been successful modes of dispute resolution in the countries where these methods have flourished and progressed. The dispute resolution on the substance of the dispute, from my point of view, which may not be a very widespread point of view, takes the resolution closer to the truth. And the beauty of a judicial decision or a good dispute resolutory decision is that it brings out the truth between the parties in the solution that is given. Here again, I think the experience of the Institute in the dozens of countries where it has its centers can help the judiciary and the other departments of government and the political departments, for instance, the parties, political parties and the chambers of commerce and the regulatory bodies, to disseminate and propagate the information about their experience in foreign territories and encourage people to adopt this form of dispute resolution. Ultimately, it's the confidence of the people in the dispute resolution system that will attract them to the modes that we are talking about. The confidence of the people will be enhanced not just by the swiftness of the decision, the lesser cost of the process, but also the correctness of the decision on the merits without the intrusion of procedural or technical pleas on the basis of which cases sometimes go off track. For instance, a very common case that we have in the court system is the law of limitation. But I know that even in arbitration, this is a objection that can be taken. But there are many forms of disputes where such an objection should not be encouraged or accepted. I would, for instance, say that in family disputes, limitation should not be an objection. Even over here, for instance, in certain other areas of the law, of limitation, for instance, adverse possession is no longer a claim that can be made because the defense of limitation has been eliminated. But anyway, this is a personal view I'm giving. Although, as a judge, I administer the law in accordance with the law. But I expect that if we can give the disputing parties a decision on the merits of the case, it is going to be far more satisfying for the purposes of the people. I don't want to say much more. I want to tell you how excited and happy I am that experts in the field of ADR and arbitration are with us in Pakistan with the objective of developing this remedy and assuring it to the people of Pakistan. I want you to know that you will be welcomed by the judiciary at all levels. And please bear in mind that the cost of the remedy must be kept affordable, depending on the type of dispute that is being resolved. Don't just focus on the dispute between rich businessmen. Also think about the disputes between poor people, people that Justice Mansoor Ali Shah was talking about a short while ago. Having said that, I welcome you and the other friends who are sitting in that huge hall, and I cannot count, but I can imagine that a large number of participants in the conference. I congratulate the organizers of this conference, and at the end of my submissions, I would like to request my learned brother, Justice Mansoor Ali Shah, to distribute the mementos to the guests on behalf of the organizers of the conference, the decision makers and the office bearers of the Chartered Institute of Arbitrators. Thank you very much. Assalamu alaikum. Banna kar. Meet kar.